All right. Hello, everybody. This is Scott Schneider from beautiful downtown Austin, Texas, and I have to read a script, which I'm not very good at, but I will do it. I am a partner in the Austin office of Husch Blackwell and a member of Husch Blackwell's higher education group, and I'm very excited that I will have an opportunity to talk with you all today about the year in review on critical labor and employment case law and regulatory developments and how they might impact colleges and universities. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'd also like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. I am here today by myself. I'm going to try to respond to questions. If I cannot do it during the program, I will happily send an email, or you can send me an email, and I promise to respond to any questions you might have. So there's also an icon to assist you with your viewing preferences. I'm just grateful that you can't view me right now because I don't look especially pretty. With that said, please note that you can expand your slide area by clicking on the maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulty, please do not rely upon me to fix them. You will be out of luck. Instead, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck and additional materials are available in the resource list icon. There are a lot of icons here. That looks like a folder at the bottom of your screen. I see it, the folder. This program has been approved for Colorado, Illinois, Iowa, Indiana, Kansas, Missouri, Nebraska, Tennessee, and Texas continuing legal education credit, and HRCI and SHRM recertification credit. Wisconsin CLE credit is pending, so we'll wait to hear about that. To report your hours in Illinois, Kansas, Nebraska, Tennessee, or Texas, click on the CLE widget. It's not an icon, it is a CLE widget at the bottom of your screen and complete the questions. A recording of the webcast will be available tomorrow for watching and sharing and enjoying. Once available, a link to the recording will be emailed to you along with a certificate of attendance. I have now read the webinar moderator script, and I am now prepared to jump right into the labor and employment law update. And I think before I do that, I'm comfortable saying, at least from my vantage point, that this has been one of the more boring years in labor and employment law. So this isn't as exciting as an update as I think I've had the last couple of years. There's some exceptions. We'll talk about those cases. But overall, this has been a pretty boring year in labor and employment law, at least with respect to those sorts of laws in cases that impact higher education. What hasn't been boring, and this is where I decide at the very beginning of this presentation to lose about 95% of the audience, is the football season of the best team in college football, the LSU Fighting Tigers. I predicted this early on before the season began, that LSU was going to win the national championship and that Joe Burrow was going to win the Heisman. I was widely ridiculed for those opinions, and look who's laughing now. I predicted this. We all know what's going to happen over the next 3 weeks. LSU will ultimately win the national championship, and the greatest quarterback in the history of college football, Joe Burrow, will win the Heisman Award. So I said this 3 months ago. Everybody said, you're wrong, you're wrong, you're wrong. again, I was right. And I'm not ashamed or bashful about pointing out that I was right. Go, as Ed Ogeron would say, go Tigers. All right. So that's my losing 95% of the audience. So let's get right into some of the labor and employment law developments for the year. It's a weird, I have a picture of Matthew McConaughey, who good friend of mine. We hang around Austin together all of the time. I wanted to talk, I don't know why I had to put him in an FLSA overtime slide, but Matthew, if you're listening, good to catch up hopefully this weekend. And sorry that the LSU Tigers beat the Longhorns a couple of months ago. So first off, we have the FLSA overtime rule, part 2. And if you can recall, during the previous administration, the Obama administration significantly increased the salary threshold for all of the white-collar exemptions. If you're not a student of the FLSA or a scholar of the FLSA, the short version is that employees who work more than 40 hours a week are entitled to overtime pay, time and a half, unless they are exempt. And there are 2 ways to determine whether or not someone is exempt, or there are 2 prongs that you need to establish in order to establish an exemption. First, that the employee performs certain duties. That's called the duty test, and that's for the executive, administrative, professional exemptions. And there is a salary basis test as well, that employees have to be making, if you're going to be exempt, a certain amount of money in order for them or you to be exempt from the overtime requirements. Under the Obama administration, there was a proposal to increase that minimum salary threshold to $47,476. Right when that was about to be implemented, there was a lawsuit filed in Texas in front of a judge who ironically was appointed by President Obama, who said this is an act and this is an oversimplification of administrative overreach. We are going to enjoin enforcement of these new FLSA overtime regulations. And ultimately, after they were enjoined, decided to strike them as administrative overreach. And so I don't know if you all know this, there was a new administration, the Trump administration came to power in 2016. This was something that they said, they indicated very early on, that they were going to revisit and likely roll back. And long story short, that's precisely what they've done. They've rolled back the minimum salary threshold for the white-collar exemptions to $35,568 per year. The analysis of this proposed rule change suggests that it's going to expand overtime pay obligations to roughly 1.3 million additional workers around the country. And this new rule, the FLSA overtime rule, part 2, will take effect January 1, 2020. I Googled to see if there was any indication that there was going to be any significant litigation challenging this, and I haven't seen anything yet. So that's relying on my Google skills, which may not be the greatest in the world, but I haven't seen, unlike when the Obama proposed regs were rolled out, and it was very clear that the National Chamber of Commerce was going to challenge those regs, I haven't seen that with this proposal here. Go from FLSA to my favorite labor and employment law, which is the National Labor Relations Act. And I'll just talk briefly about a case involving the University of Southern California that was decided in the D.C. Circuit Court of Appeals. Short version of the facts. There was a group of non-tenure track faculty members who sought to organize a union, ultimately petitioned for an election, and ultimately won. And the University of Southern California refused to bargain with this newly elected union of non-tenure track professors on the basis that those professors qualified as managerial employees under the National Labor Relations Act and therefore could not organize. The National Labor Relations Board, in considering unfair labor practice charges against the University of Southern California for failing to negotiate with the duly elected bargaining unit, basically the University of Southern California argued, look, that non-tenured faculty serve on committees that recommend policy changes, make recommendations about curriculum, all the sorts of things that managers do, and therefore they were managers. And short version, what the NLRB said was, look, they serve on those committees, but they don't represent a majority of those committees, and therefore they are not managers. Well, the University of Southern California decided to appeal this. They could have appealed it to the Ninth Circuit or the D.C. Circuit Court of Appeals. They appealed to the D.C. Circuit Court of Appeals, and the court, in essence, rejected what was dubbed the board's subgroup majority status rule. They said whether they constitute a majority or a minority on that committee, if they share the same sort of interest with the tenure line faculty, what we then have to do is apply the Pacific Lutheran University standard to assess whether or not they exercise the sort of effective control that is typically attributed to managers. So we need to do, it's not enough to say they're a minority on that committee. What we need to do is look at the work of that committee to see what it is they do, and do they, in essence, exercise effective control. Specifically, we need to look, does that committee make recommendations that almost always are followed by the administration and routinely become operative without independent administrative review? And if the answer to those questions is yes, then even these non-tenure track faculty members are managerial and therefore they cannot organize. We'll stick with the National Labor Relations Act for one more second, and we'll talk about some proposed regulations that are coming out about an issue that I think if you go back probably 40 years has gone back and forth depending on which administration is in power at the National Labor Relations Board, and that is the extent to which grad students can organize under the National Labor Relations Act. Short version is, if they are students participating in an educational program and perceived as students, they cannot organize. If they are grad students but perceived as or considered to be employees, they can organize. And again, depending on which administration has been in power with the National Labor Relations Board, the board in Washington's interpretation of that has changed. Here, for the first time, there is a proposed regulation which would say that students who perform services in connection with their studies, employment services in connection with their studies, are not employees for purposes of the National Labor Relations Act, and therefore they cannot organize. All right? So that is a proposed regulation. It is short, it is sweet. I think they just extended the period, the notice and comment period on this proposed regulation. But the net impact, I think, would be obviously, three things. Number one, that if we end up with this as a final regulation, grad students in private institutions would not be able to organize and join unions and seek the benefits that are provided by the National Labor Relations Act. That is number one. Number two is this would perhaps bind future administrations in the way they interpret this issue and deal with this issue, because it apparently is much easier to overrule precedent in the National Labor Relations Board than perhaps it is to rewrite or overturn regulations. And three, this sort of came up this week, and a good colleague, a fantastic colleague of mine in California mentioned this, that we have right now, and I think of the Harvard case right now, instances where grad students are going out on strike because they haven't been able to negotiate contracts or renegotiate contracts. The designation of those grad students as students and not employees would also impact the extent to which they could engage in protected concerted activity. If they're not employees, if they're students, then they're not protected by the National Labor Relations Act's prohibitions on retaliation for concerted activity. So it will be interesting to see how this plays itself out. I would expect to get a final regulation sometime in April or May for that. All right, I'm going to do. This is a clean-shaven David Letterman, who is a bit of a hero for me. We're going to do the top 10, what I think are most significant labor and employment law cases. This is all inspired by David Letterman. Thank you, Mr. Letterman. He might actually be listening to this with Matthew McConaughey today. I look forward to hanging out with you as well, old friend. We'll start with probably the most significant pending employment law issue before the Supreme Court, and that would be the Zarda, Bostic, and Harris Funeral Homes cases. Short version is Title VII's prohibition on sex discrimination. What does that mean? And more specifically, does it protect employees from discrimination on the basis of their transgender status or gender identity or their sexual orientation? Very interesting, and by the way, I would recommend, you can find the oral arguments online. Very, very interesting back and forth. You can almost predict that there are definitely 4 votes, the liberal justices, who are willing to extend Title VII's protections to protect employees who are discriminated against on the basis of sexual orientation. There are clearly 4 votes for that position. Same with transgender status. On the orientation question, there were really interesting questions that were posed by, oh gosh, now I'm going to forget his name. I'm having a moment, a middle-aged moment. Oh, the first justice that Bush appointed, not Bush, but Trump appointed. Really interesting questions suggesting that he might be open to the possibility of extending protections to employees on the basis of sexual orientation and gender identity status. Oh, this is going to make me crazy. I can't remember. I can see his face, and I can't remember his name. It's going to make me nuts. One of the other interesting things, if you read the transcript of this oral, or of both oral arguments, is there is a lot of interest about how this impacts interpretations of Title IX, specifically around the bathroom issue, and even there was some discussion about what about transgender athletes. Now, to the advocates' probably credit, they decided not to address those sorts of questions. They are complicated questions, and they avoided them, but it's very clear that the way in which the court interprets these cases in Title VII in this context will also have a ripple effect on how courts, subsequent courts, lower courts, interpret Title IX as well. But it's a really, there's also some discussion that a lot of the argument on the plaintiff side relies on that Price Waterhouse gender stereotyping argument in favor of, hey, this is the sort of gender stereotyping that violates Title VII. And there's some concern, although I don't see it in the actual oral argument transcript, that the Supreme Court, in ruling on these decisions, will roll back its holding in Price Waterhouse. I've seen people say that. If you read the transcripts of the oral arguments, I do find that hard to believe, and I think it is unduly alarmist. So we'll wait to see what the court's ruling is on these issues. The ruling would clearly resolve fairly significant circuit splits on these issues. And again, we'll have some implications for Title IX. A less interesting case, in one I talked about last year, perhaps, is Rizzo versus Jovino. This is one of my favorite, most interesting cases of last year, and I'm bringing it up this year because the Supreme Court weighed in on it. So, long story short, this is an Equal Pay Act claim. And under the Equal Pay Act, one of the obligations of a plaintiff is to be able to establish that he or she, in making a comparison about pay, works in a job that requires equal skill, effort, and responsibility, and which are performed under similar working conditions. There is an affirmative defense for employers in Equal Pay Act claims, and that is to be able to say that if there is a disparity among people who are working in positions that require equal skill, effort, and responsibility, it is attributable to a seniority system. It's attributable to a merit system, a system which measures earnings by quantity or quality of production, or, and this was the catch-all, and it's significant, a differential based on any other factor other than sex. And so in Rizzo versus Jovino, this is an en banc decision from 2018, what the defendant sought to argue is, yes, they have, in essence, equal jobs, and they're making different amounts of money, that the male is making more than the female, but we are relying in making that determination. Yeah, thank you, Emily. That was going to make me crazy. Neil Gorsuch. Thank you, God. I can now sleep again. Thank you, Emily. But long story short, what the defendant was arguing was the reason the male is making more than the female is we looked at their history of compensation prior to coming to this job. All right, and that falls within the catch-all. It is a differential based on any other factor other than sex. And so the issue that was in front of the Ninth Circuit was, can an employer rely on prior salary history in establishing this affirmative defense to an Equal Pay Act claim? And by the way, there are a number of states, I think of Hawaii jumps to mind, that have come out and said, no, you can't do that. That would violate state law. Here we have Judge Stephen Reinhart writing for the majority, and to summarize it quickly, he comes back and says, no, this is in essence past discrimination being allowed to serve as the justification for current discrimination, and relying on prior salary history does not fall within that catch-all exception. The defendants decided to appeal that decision to the Supreme Court. And they had a very novel and unique argument, which was that this decision, which relied on Justice Reinhart's vote, was issued after Justice Reinhart had died. So this goes up to the Supreme Court. They also address the other merits of the Equal Pay Act claim, goes up to the Supreme Court, and it's one of my favorite lines from a Supreme Court decision in a long time. I will read it. Because Judge Reinhart was no longer a judge at the time when the en banc decision in this case was filed, the Ninth Circuit erred in counting him as a member of the majority. That practice effectively allowed a deceased judge to exercise the judicial power of the United States after his death. And here it is, you ready? But federal judges are appointed for life, not for eternity. This is a great little line, strikes the decision in the Ninth Circuit. There is still a circuit split on that issue, specifically the extent to which you can rely on previous salary history in making current salary decisions, and it was not resolved by the Supreme Court. We've seen an uptick, I think nationally, certainly in my practice, of Equal Pay Act related claims. We've also seen a lot of interesting dispositive motion practice. I think universities have been reasonably successful in the litigation of these claims. Just to give you an example, my friends at the University of Alabama, Roll Tide, the case Heatherly versus the University of Alabama. Here we had a plaintiff making an Equal Pay Act claim, alleging that she had the same or similar job responsibilities as a number of male competitors. Long story short, and it really lays out, this case I think lays out in a very interesting way the framework for assessing these sorts of claims, but the court comes back and says, first off, a plaintiff has a very high burden in establishing the similarity in working conditions and job duties. And here, in the Heatherly case, she was unable to do that, and for that reason, the university's motion for summary judgment was granted. In addition, long story short, she didn't have significant evidence of significant enough pay discrepancies. And so, again, I've seen an uptick, at least in terms of the amount of litigation that is being filed in this space. Equal Pay Act claims primarily in terms of, I'm seeing it in terms of coaching, assistant coaching contracts and faculty contracts. And at least to date, I think the case law has been fairly positive for universities. And Heatherly, I think, does a good job of setting up the framework for assessing those cases. The only Star Wars reference that you will see today, this is another Supreme Court case, really nerdy issue that I've actually litigated probably a decade ago. The question is, well, let me back up. In order to file a claim under Title VII, plaintiffs are obligated to file a charge of discrimination, and prior to filing the litigation, they are supposed to receive what's called a notice of right to sue, which if you file a charge of discrimination, you get. What happens, though, if a plaintiff decides to file a Title VII claim prior to either filing a charge of discrimination or getting a notice of right to sue? And the nerdier framing of that issue is that a jurisdictional prerequisite to filing lawsuits, i.e., the sort of prerequisite that cannot be waived at any point? For a federal court to hear a Title VII case, they have to have subject matter jurisdiction. And if you view this as a jurisdictional issue, the person who doesn't file a charge or doesn't get a notice of right to sue letter, the court doesn't have appropriate jurisdiction, and that issue then can be raised at any point in the litigation to seek a dismissal. Or is it something else? Is it some sort of case management process, and so, or a claim processing issue? And so in Fort Bend versus Davis, the court, in a unanimous decision, said these prerequisites to filing Title VII suits are not jurisdictional. They are case processing issues. And therefore, and here is why I put it's a trap, the reason I put it is a trap is because if you don't raise the failure to exhaust administrative remedies on the front end, you can waive it. It is not a jurisdictional challenge to a court. It needs to be raised. And so that is the trap. That is not the most exciting case in the world, but potentially significant. I'm going to talk about a case, though, that I think is super significant. And I apologize for this being so wordy, but it is definitely worth a look. What we've seen throughout higher education over the last 5 years is a significant uptick in the number of respondent-initiated Title IX claims in the student context. And they go something like this. University failed to follow their procedures. They found me responsible to quell an angry mob of protesters who said we didn't take this issue seriously, or to convince OCR that they were taking this issue seriously, fill in the blanks. And therefore, in disciplining me, they violated Title IX. I am now a victim of discrimination on the basis of sex. And I think what a lot of folks were saying is it's hard to understand why that sort of legal argument wouldn't be able to apply with equal force in the Title VII context. When we decide to fire an employee for violating an anti-harassment or an anti-discrimination policy, do we potentially have liability under Title VII based on arguments that we've seen in the context of Title IX? You didn't follow your procedures. You were, basically trying to placate protesters. You were trying to placate the government who had put pressure on you, et cetera. And so in Menaker versus Hofstra University, this is the First Circuit court case I was able to find on this, and I'm sure there are others. But it's one of the first times that I can see where a Circuit Court of Appeals comes in and says, that case law we've developed within the context of Title IX, and that was in the Second Circuit, the Doe versus Columbia case, yeah, it also applies in the Title VII space as well. And so, in the past, I think when we think of Title VII cases, one of the arguments, if anybody said, well, you deviated from your policies and procedures, we would argue that, well, so what? We're not contractually bound by our employment policies and procedures, at least in courts in the Fifth Circuit, which is where I primarily practice. But what the Menaker case is basically saying is that, coupled with some other facts, might be enough to at least survive a motion to dismiss and suggest that you were discriminating against this person on the basis of sex. I think this is a significant decision. I also think it is potentially a harbinger of things to come, and I am a little bit surprised that it hasn't received a little more attention, and I do recommend that you read the decision. All right, we'll go on to a couple of cases that maybe I find interesting because I'm worried they may apply to me at some point. So Richardson versus Chicago Transit Authority is a Seventh Circuit case out of, it's a 2019 case out of the Seventh Circuit. The issue in front of the Seventh Circuit was we have Mark Richardson, who's a bus driver. He weighs 566 pounds. The problem was the seat that he was sitting on could only accommodate someone who was 400 pounds. And therefore, after a lot of rigmarole, and I'm doing a very quick summary of the facts, ultimately the Chicago Transit Authority said, look, you can't be a bus driver. And so Richardson decided to sue the Chicago Transit Authority, saying that my weight, my extreme obesity, is a disability, and therefore you violated the Americans with Disabilities Act because you didn't offer me the interactive process or reasonable accommodations. And so I thought this was a significant case because it's one of the very few decisions you see nowadays where a court sees an impairment of some sort and says, no, it ain't a disability. Generally speaking, what you're seeing is for virtually every impairment, the court saying, yep, that would qualify as a disability. And here, the Seventh Circuit said, no, the mere fact that he was morbidly obese, without being able to connect that to some sort of physiological disorder or condition, that's not enough to establish that the person has a disability, which subjects them to the protections of the Americans with Disabilities Act. Now, it may be one way of interpreting this case is his lawyer didn't plead this appropriately, but again, interesting case in that it's one of the very few cases that I've seen where a court says that impairment is not a disability protected by the ADA. A little closer to home is Lewis versus the University of Pennsylvania. Very interesting case where there is a police officer who, like all real manly men, wants to grow a really long beard, real manly beard. And he not only wants to do that because it makes him look prettier, but he doesn't want to have to shave because it irritates a skin condition that he has. Now, this is in the motion to dismiss setting, so we're assuming the facts as pled by the plaintiff are correct. According to the plaintiff, when he said, hey, I don't want to shave anymore, I want to make an accommodation where I can grow my beard, and according to Lewis, the University of Pennsylvania said, nope, we're not allowing that, and we're not going to engage in the interactive process. And he also made, in essence, a constructive discharge claim, an ADA claim as well, both of which were dismissed at the district court level. Case goes up to the Third Circuit Court of Appeals. Third Circuit Court of Appeals says, you know what, you've alleged enough here to state a viable constructive discharge claim. Number one, you were disciplined, your job responsibilities were significantly altered, you had a preferred assignment as a campus law enforcement officer that you were removed from, you were threatened with discharge, you had your pay and benefits reduced. That's enough. You pled enough facts to establish potentially a constructive discharge. I don't think there's anything remarkable about that. The court also said that, look, this skin condition is the sort of impairment that would qualify as a disability, and it's up to a jury to ultimately decide whether permanently exempting the plaintiff from shaving would have been a reasonable accommodation. So we'll wait and see how that one unfolds. Buchanan versus Alexander, Fifth Circuit case involving the LSU Fighting Tigers. Not the Fighting Tigers, but Louisiana State University. This is another issue that we're seeing more and more often, certainly in the public sphere. This sort of tension between anti-harassment policies, anti-discrimination policies, and free speech rights of faculty members or staff and employees. Really interesting back and forth involving Indiana University. I won't get into the weeds on that one, and I thought they handled that case in a very unique way involving the provost. If you haven't read about it, Google it, or I'll send you some links to it. But in Buchanan versus Alexander, and Alexander is the president of LSU, Teresa Buchanan was a tenured professor who taught, I think it was a K through 3 program. So she's teaching basically future K through 3 teachers. The facts are pretty straightforward. There were allegations that while she was teaching, she would make a number of inappropriate sexual comments to students in the course. The students got fed up, filed a complaint. It went through the university's Title IX apparatus, and ultimately the administration decided that the violation of the institution's Title IX policy was so severe and significant that it revoked her tenure and terminated her from the university. This decision received the attention of FIRE, which decided to participate as an amicus in this lawsuit that she filed against LSU. And the gist of her lawsuit was that she was engaged in speech that was protected by the First Amendment, and that her termination violated, therefore, the First Amendment. And what she tried to do is connect to the speech about what the Fifth Circuit ultimately dubbed her private sexual life to course pedagogy, to say, look, this falls within the ambit of traditional academic freedom, okay? And so this case goes to the district court. It is dismissed at the district court level, a fantastic opinion, 60 pages long, by Judge Dick in the Middle District of Louisiana, which lays out the framework for assessing First Amendment claims in the context of public employment, public academic employment, then goes up to the Fifth Circuit Court of Appeals. And they say a few interesting things, ultimately, by the way, siding with LSU. They set up the framework this way. First, there is this open question. There's a case called Garcetti that was decided by the Supreme Court. The holding in Garcetti is basically this. When a public employee comments about things within the course and scope of his or her employment, it's not protected speech, and you can be disciplined for that. Now, when Justice Kennedy wrote that decision in Garcetti, he said, we need to be careful here about whether or not and how this applies to the university setting, because teachers, for instance, working in the course and scope of their employment are teaching, and we have this notion that we recognized 50 years ago of academic freedom. And we think it's important that professors feel comfortable speaking about controversial topics in their classes. That was dicta in the Garcetti case. In this Fifth Circuit decision, the Fifth Circuit comes back and says, we don't think Garcetti applies within the higher education academic setting. We don't think because academic freedom interests trump the operational interests. And they say academic freedom is a special concern of the First Amendment, which does not tolerate laws that cast a pall of orthodoxy over the classrooms. What they say is they set up, the traditional First Amendment test for assessing these cases. Was Professor Buchanan speaking on a matter of public concern? If she's not, if she's speaking about a matter of purely private concern, her speech is not entitled to First Amendment protections. And short version is ultimately the Fifth Circuit came back and said her discussion of profanity, the discussion of her sex life and the sex lives of her students was not related to the subject matter or purpose of the training, therefore was a matter of purely private concern, therefore no First Amendment issue in play. Similar case with somewhat different facts involves the University of Illinois. And this is a case, I'll just fast forward right to it, Wozniak versus Adesita out of the Seventh Circuit in August of 2019. This Professor Wozniak, was a professor in the Department of Industrial and Enterprise System Engineering at the university. He had been a long time tenured professor at the university, and apparently some students got together and had the audacity to award a teaching award to a professor other than Professor Wozniak. Right? How dare they? They didn't think he was the best professor. And Professor Wozniak is very upset about this, starts blogging about it, starts harassing the students, etc. Also, I think, and I could be screwing this up, decided to file a lawsuit against the students with the sole purpose of harassing those students. The University of Illinois is obviously and rightfully upset with this behavior and decides ultimately to revoke Wozniak's tenure. Same issue he raises that Teresa Buchanan raises. This violates my First Amendment rights. Here in the Seventh Circuit, Ultimately, the Seventh Circuit said, no, this is not a matter of public concern. You're not speaking about a matter of public concern. This is truly private concern. You didn't get an award, and you're upset about it. They also say, and it's not clear to me, though, whether this is the holding or if it's dicta, they also said, and oh, by the way, you did it within the course and scope of your employment, and therefore Garcetti applies. And for that reason, it's not protected speech. So that will be interesting to see. That suggests there might be a circuit split on that issue. It's just worth pointing out that for private schools who, you're glazing over when you hear this discussion of First Amendment issues, it's important to recognize, think about the McAdams versus Marquette case, where in essence the Wisconsin Supreme Court came back and said, you might not have a constitutional obligation to honor academic freedom or First Amendment protections of your faculty, but you can agree to do that via contract, through your appointment letter, through your faculty handbook. And so, yes, technically these cases involving public schools don't apply to private schools, but they might, depending on what our academic appointment letter says, what our faculty handbooks say with respect to professors' rights to academic freedom. I would be remiss if I did not discuss just briefly the Oberlin case, which it's complicated. I'm going to oversimplify it a little bit. But for those of you all who don't know about this case, obviously anytime we see a $40+ million jury verdict against the university, it's something we should be probably paying attention to. And so at Oberlin, there was an incident involving a bakery. It was called Gibson's Bakery. And the owners of Gibson's saw an Oberlin student who was African American come in to the bakery, and the owners thought they saw the student shoplifting. And so as the student was leaving, the student ran out, and so the owner of of Gibson's decided to chase the student, tackled him. There was a melee that ensued involving him and some other people. A number of Oberlin students ended up seeing this, and this is right after the election of President Trump. A lot of the Oberlin students started seeing this and thought it was an act of racial profiling, racial discrimination, et cetera. And they start making phone calls to the police. They start, calling administrators at the school, et cetera. In this case, ultimately, it's worth pointing out that the students were, in fact, shoplifting. There was no evidence that the owners of Gibson's had engaged in this instance or any other instance in any act of racial profiling. The students, though, they've seen what they've seen. They decide to organize protests. And this is the sort of protest where there is a potential of spillover violence, because apparently the community around Oberlin is fairly conservative, whereas Oberlin is a bit more liberal. And so administrators are concerned that if there is protest, there might be people from the community who come in, there might be violence. And so what we want to do is make sure that we as university officials are monitoring this protest. And so some of the student affairs personnel go. One of the student affairs personnel, the dean of students, is accused of, while in the course and scope of her employment, passing out a flyer accusing Oberlin of engaging in a lengthy history of racial profiling and being racist. All right? Fast forward. At various points, the Gibsons try to get Oberlin to issue an apology. There's some discussion about this. But ultimately, they sue Oberlin and this dean of students for defamation. And so and ultimately in a case that is subject to appeal, and I do think has a number of spin-off, potentially interesting free expression issues, but a case that is now subject to appeal. I think one way of thinking about the Oberlin case from a labor and employment law perspective is that it is a labor and employment law case, and it is under what set of circumstances will you be vicariously liable for the torts that a jury says were committed by one of your employees. Now, it's worth pointing out that Oberlin has denied repeatedly that the dean was engaged in any sort of defamatory speech, that she was there to do her job, which was to monitor and make sure the protest was conducted safely. But I think there's one way of thinking about the Oberlin case, and that is to think of it as sort of a traditional labor and employment case, a traditional respondeat superior or vicarious liability case. I'll close with, you don't see a whole lot of these anymore, but back in the day we sure did, and that is a disparate impact claim. And this one I thought was fairly interesting. It's Kukuk, I think I'm saying that right, versus Central Washington University. And here we have a professor who is denied tenure because he received his terminal degree from a school that wasn't accredited by the accrediting body, the Association to Advance Collegiate Schools of Business, which says, in order to get tenure, you have to have a terminal degree from one of our accredited institutions. He is Turkish. He receives his terminal degree in Turkey, and therefore that one's not accredited by this accrediting body, and he is denied tenure because of that. Now, he's not going to be able to argue that he is a victim of intentional discrimination. What he's going to argue is this facially neutral rule about requiring an employee to have a terminal, or requiring a tenure candidate to have a terminal degree from an accredited institution, that has a disparate impact on the basis of race and national origin. Ninth Circuit Court of Appeals considers that argument and says, no, Central Washington has articulated a business need to have that requirement because the alternative is they potentially lose their accreditation. And oh, by the way, you haven't provided us with sufficient statistical evidence of a disparate impact here. Case is denied. And I haven't seen a really interesting disparate impact case in higher ed for quite a while. So long story short, it will be, I think for me, it was a fairly boring year in labor and employment law. It will be interesting to see what the Supreme Court comes back with on the Title VII cases. I think we will continue to see, with the proliferation of social media in particular, this push to deal more aggressively perhaps with speech issues and that maybe touch on sex discrimination policies, anti-discrimination policies, and it will be interesting to see how schools navigate through those. I also think that what we have seen on the respondent side in Title IX litigation, there is a possibility that we might start seeing that sort of litigation a little more frequently on the employment side. I have 5 minutes. I've never been beneath time. I'm stunned. I'm going to read questions. Neil Gorsuch. Look, if you have, I'm having a hard time reading these questions. If you have any questions, feel free to send me an email. You can see my email address, I think, on this slide. Happy to answer it. I'm not going to bill you for it or anything like that, but I've enjoyed spending time with you all today. Take care. Thanks.